Rivers State government has stated that the recent Court of Appeal judgment in Abuja did not reinstate the Martin Amaewhule-led faction of the State House of Assembly, dismissing claims that they remain members of the Assembly. In a statement issued on Thursday by the State Attorney General and Commissioner for Justice, Israel Dagogo Ibromas, SAN, the government insisted that Amaewhule and 26 other lawmakers had automatically vacated their seats upon their defection from the People's Democratic Party to the All Progressive Congress on December 11, 2023. According to Ibroma, this defection triggered Section 109 subsection 1G of the 1999 Constitution, which mandates that lawmakers who switch political parties lose their seats. The issue of defection of Martin Amaewhule and 26 others was never before the Federal High Court or the Court of Appeal. Therefore, no court has legitimized their membership of the House of Assembly following their defection, Iboroma emphasized. The Attorney General further explained that the case at the Federal High Court and the subsequent appeal concerned the 2023 appropriation law and the National Assembly's intervention in Rivers State's legislative functions, not the status of the defected lawmakers. Following the dismissal of the state's appeal regarding the 2023 appropriation law by the Court of Appeal, Ibroma criticized the misrepresentation of the ruling. There is a wave of false reports suggesting that Amaewhule and the others remain in the assembly with him as speaker. This is patently untrue, he stated. The Attorney General also announced that the state government would appeal the ruling to the Supreme Court and file an application for a stay of execution to maintain the current status quo. Governor Similaye Fubara, according to Iboroma, has urged the people of Rivers State to disregard any misleading reports regarding the court's judgment and assure them that the legal steps are being taken to resolve the matter. So you cannot continue with your
Yes, I said the decision of the Court of Appeal yesterday has taken us back to sometimes in 2023. Thank God the date is clear, December 11th, where there was a defection. Prior to their defection, they had initiated the suit before Federal High Court, presided over my Lord Justice Omotosho. Now, upon their defection, to those of us who believe that Section 109 is self-executory, we held and still hold the view that they lost their seats. The Chief of Staff now, what's his name, Edison, came into force upon the order of court. This set of persons haven't defected. They were remaining only 5 members of the House who never defected and in law seemed to be the valid members of the House. And so the court agreed with them and gave them the order to go ahead and function in that capacity. And upon emerging as the Speaker of the House, he activated Section 2 of subsection 2 of Section 109, declaring their seat vacant. And so if that decision is reached one way or the other, and assuming the court agrees that indeed there was a defection, and that defection was not in compliance with Section 109, subsection 1G of the Constitution, what is the status of these persons, again, in instituting this action, and to what extent is the benefit of the decision of the Court of Appeal yesterday?
Right.
Because they have lost their membership. And therefore, the issue as to whether or not, as at when he initiated the action, he was still the Speaker of House of Assembly.
Who was still the Speaker of the House of Assembly?
As to when they instituted the action. He, claiming that he was the Speaker of the Rivers State House of Assembly, agreed, but upon defection, losing your seat, do you still maintain that status? So that is the question that, to me, I've looked at all these and I've come to the conclusion that the celebration is, I would like to use some certain words, it's just going to be short-lived.
Right. All right. Before I come to Barrister Ndamzi, I still have questions to ask you with regards to what you've said. Now, you recall when we were on the first conversation, you said, Barrister Jamala, that when it comes to issues of states, like the appropriation bill, it is the jurisdiction of the state high court to legislate over it. However, when it comes to the seats of the members of the State House of Assembly,
determination as to whether or not.
Yes, you said that it has to do with the Federal High Court has the jurisdiction over state high courts in that regard. However, you recall that Edison here's, or would I say, authentication or declaration in this instance as a speaker of the factional speaker of Rivers State House of Assembly was done by a state high court, which by his explanation does not even have the jurisdiction to even handle that matter or declare him the speaker.
The court.
When it still boils down to jurisdiction.
Are you done?
Edison here was, will I say or use the word authenticated? No. Edison here was declared speaker of the House of a factional Rivers State House of Assembly by a state high court.
No, that is not true.
Which federal high court?
That is not true. Not
Which justice?
The court.
Which court?
The court, Rivers State High Court, did not declare. Let's get it right. Did not declare Edison speaker.
What happened exactly?
The court only approved their sitting. The court only asked that they are members, valid members of the Rivers State
High Courts have the jurisdiction to approve?
I'm coming.
Plenary of a state high court.
Whether this court has jurisdiction or not is a subject of an appeal.
Hold on.
Let's not go into that.
So if you say that is a subject, it still boils down the question I want to ask. You just led me to the next question.
Yes. Let me answer the first one now.
Allow
me to learn.
Okay, go on.
The court never declared Edison speaker. The court only approved that upon the defection of these persons, you people are valid members of the House, rightly or wrongly.
That still boils down to the exact question I asked you. Does a state high court even have the jurisdiction to even handle that matter and say upon the defection? Does the state high court have the jurisdiction to determine the defection of state high of state houses of assembly?
Where a court?
We are still boiling down to the now.
Where a court errs in law. That is why we have.
Secondly,
yes. Let me ask.
If there is a proviso.
To what?
If there is a constitution and under that law,
yes,
there is a proviso.
Yes.
Who determines whether the proviso is or let me rephrase it. Is it not the court that will determine
precedent?
Yes, whether the conditions of the provisos were met or not, particularly if it is under contention?
Why we await the decision of the court in that regard? Chama, it will not stop me from thinking and believing so. That
however,
I'm coming.
However, a court has already said
a court has
here about Martin Amaewhule remains.
That is on one bread. There are two different suits.
And you have said yourself.
Yes, there are two different suits.
Choma. You have said yourself that.
Yes.
When this suit was instituted by Martin Amaewhule,
yes,
one of the prayers was that the court, the Federal High Court, should declare him speaker or authenticate his speakership. Martin Amaewhule should be, his speakership should be authenticated. Now, the Rivers State government responded and did their own counter affidavit and all of that. And in that counter affidavit, of course, by that time, they have already defected. And accusations of those defections would have been included in it. Question is, why withdraw? So if the state government willingly,
let's not go into that.
It is a you can't take it away. If the state government willingly withdrew that counter affidavit.
Let's not go into the fact of the reason why.
Are we not back to status quo?
I'm coming, Choma. Let's not go into the reason why they withdrew those things. You and I know.
The question, I'm not talking about the reason.
If I decide to,
the question is
to my father to take a particular action.
You're being sentimental.
You are looking at the fact. I am not. It is the understanding of sentiment
hold on. The question, I am not asking.
You use the word willingly withdraw.
I am not. They withdrew willingly. There was no gun to their head. Because the governor as well chose the other items in the peace pact. He refused to.
But they withdrew all the actions.
So, hold on. The governor also, in the peace pact that he signed,
yes,
there were also other conditions in the peace pact.
Like
he did not. Hold on, Jamala, hold on. There were also some other conditions in the peace pact. He willingly decided not to obey, and heavens did not fall.
Which of them? So I want to know which of them, because
Jamala, I won't let you play that game. You not deflect.
No, to my own understanding,
the question I want to ask you is this: you said defection was not part of the prayers initially.
Yes.
However, as at the time this matter, before the judgment was given, Martin Amaewhule had already defected.
Yes.
And the Rivers State government also submitted their own counter affidavit, and also part of all that was allegations leveled against Martin Amaewhule was their defection. However, Rivers State government, for whatever reason, willingly withdrew their own counter affidavit and withdrew themselves from that matter, and judgment was given. If they had withdrawn that allegation and subsequently the governor still related with Martin Amaewhule, what does that say? So when you say that you don't want to, it is all embroiled because we are back to status quo. So the government on one hand...
Can I talk now?
Yes, you can. But the government on one hand cannot, by their own sentiments, set the law aside over a matter that they have willingly withdrawn and said,
you are beginning to turn to...
And on the other hand...
Rather than a moderator, you are beginning to dance into the arena.
However you present it...
Don't dance into the arena, moderate.
Hold on. However you will not teach me my job. I will do it the way I want to do it.
I agree, but let it be seen that you are moderating.
I'm not exactly the regular moderator you see. This is Laurentia, and this is my modus operandi.
Okay.
As long as it gets you to talk, which you're doing already. So now, at the end of the day,
yes,
the government willingly withdrew. And when the matter did not favor them, the government is now saying they are not known by the law.
Yes.
But the law is saying that Edison here is not known as the speaker. So Jamala, make it make sense.
Yes,
Is the government not confused in
the
this
government
instance?
is not confused. Please.
So what's going on?
Although the matters are correlated, they are two different suits. Let's get it right first.
All right.
The one that was, the judgment was given by Omotosho has to do with relationship with the executive and the legislature. The ones pending at the Rivers State Federal High Court Judicial Division has to do with defection.
Why did Justice Bassam recuse himself?
What?
Why did Justice Bassam?
There were several suits. Even there, one of your report talking about local government law extension.
Why did Justice
I'm not aware
Bassam,
if you can educate me.
You know, I find it very, very, very interesting that you choose what to remember and what not to remember.
I am not an
We have discussed Justice Bassam on my show, and you were a guest.
I am not encyclopedia.
So you don't know why...
I'm a human being and my memory could fail me also.
And interestingly, you remember all the sections of Nigerian Constitution.
I don't remember.
But you do not remember...
I know the one that
you do not remember
discussions.
Oh, that's it. So are you saying
I do my research before coming?
Are you saying you don't know?
Can you remind me what
you don't know why Justice Bassam recused himself?
I want to know why Justice Bassam recused. In which of the matters?
I will find out.
I'm aware that Justice Nwogu declared dismissed one of the suit for lacking jurisdiction. I don't know of Bassam. If you can remind me, I will attend to it. But let's please. You are always deviating. The facts are different facts. One has to do with relationship with the legislature. The other one has to do with defection. And I said this suit predates their defection. Assuming they were right, which I agree to some extent, that assuming we are members of the House, can the governor stop to relate with us? Rather relate with some set of persons? That was their grievance. And if the court says no, the governor is wrong, then God, please mandate the governor to do so.
Which they did.
Which the court did. I am coming.
Go on.
The issue of defection has not been decided.
By who?
By the court.
Which court?
The Federal High Court.
Of which judge?
Obile Court 1 and Court 4. It started with Court 4.
Instituted by who?
Instituted by some members of Rivers State and civil societies. It's pending. Are you not aware? Are you also selected in your memory?
Are you aware?
Are you aware of those pending cases?
Are you aware of cases that were thrown out at the Federal High Court on the ground that the people or the appellants do not even have locus to present that matter?
It is not even the Federal High Court. It was the State High Court. That is the Wogo brought by Rivers elders. That is Justice Nwogu, not Federal, not what do you call it? Federal High Court. The Federal High Court has not decided. My colleague is here to lay credence to that.
Ndamzi, do you know why Justice Bassam recused himself?
Yes, of course.
Go
on. Bassam did not recuse himself.
Did not. He gave a judgment.
Struck out the matter. That his court doesn't have jurisdiction to entertain any matter related to House of Assembly thereto.
And
That
Justice
is the
Bassam is
position.
of the State High Court.
Yes, of
correct?
course. That is the
All right.
position of the law.
Do you recall what he said with regards to the defection of the lawmakers?
He said that
Even
their
though that
defection
cannot be
is unknown to the
implemented.
law,
All
and
right.
that they still remain valid members of the PDP.
All right.
That was, although that was a
An
ratio, an obiter.
And
You
it's
know,
not
it wasn't a
implementable.
ratio.
Yes.
Yes, it's just a statement made by a judge while delivering a judgment.
All right.
Yes. So, on this discussion so far, the AG saying the seats of the 27 members of House of Assembly remains vacant. I think I respectfully, I will differ with the AG completely here. Why do I say this? I want to cast our mind back to why Edison went to court. Because my colleague made mention of the fact that the matter predates the defection. I want to disagree with him. The matter never predated defection.
The
In
one
sense
decided
that-
by your motor show?
No,
That is the matter I'm talking about. The matter-
No, I am referring to the reason Edison went to court.
No, I'm not talking about Edison going to court. I said the matter presided
talking
over
about
by
by
motor show
Okay.
predates their defection.
Okay. Edison went to court and Justice, what's his name? C.N. Wale. Okay. C.N. Wale recognized the Okojombo-led assembly. All right. Edison went to court. And if we look at the Court of Appeal judgment, the previous judgment, that judgment, the Court of Appeal was very clear in saying that Edison never existed as speaker in the eyes of the law. And that all acts and omission done by that assembly was null and void. That is to say, including the appropriation bill that Edison approved for the governor, null and void. That is to say, all actions of Okojombo and his team, including the clearing of commissioners, SAs, clearing of the illegal caretaker committees, were all null and void. So, if the Court of Appeal, in their wisdom, could have declared actions of a purported speaker whom the government is recognizing null and void, so what do we think in the eyes of the law will stand? Now, in reconciling the current position, I reiterated where we were talking of on the first topic here. The affidavit deposed by Martins and Co. One of their prayers in that suit was that the court should authenticate his speakership. So, the government withdrew their matter, and the court went ahead and gave that judgment in line with the prayers of Martins. The court authenticated. No, Jamala, we shouldn't.
The speaker, I remember I said
no,
it was.
We shouldn't.
The issues of defection was never decided by your motor show. True or false?
See, listen.
Was it decided by your motor show? The issue
The-
of
the
defection,
issue- the
whether
issue-
the legality or not, was it defected? Was it
See,
attended
do
to
not
by your motor
forget
show?
that
What-
in every
Before we
matter
proceed
before
now,
the
Council,
court.
Don't even have much
No,
time.
before
Before
in
we
a
proceed,
matter
don't-
before
you're
the court,
interjecting. No,
these
allow me to-
matters
it's
have
not-
different facts in issue. Okay.
Point.
Now, in Amaewhule's affidavit, it was very clear. Amaewhule is saying, court, declare my speakership authentic. The court, in its wisdom, have gone ahead to say Martin's speakership is the rightful speakership of the House.
Assuming.
And no, not in assumption. The court of appeal was very clear in stating that, and that the position of the 27 members are clear. They remain the valid members of the House of
Does that
Assembly.
settle the issues of law with respect to defection?
The question
Of law.
of defection
Yes. Does that
The
settle
question
it?
of defection,
Yeah.
the Supreme Court will settle that.
It has not even gotten to the Supreme
The
Court.
Supreme Court will settle that. I am very aware that the Supreme Court will consolidate all the House of Assembly matter and come up with a decision. But so far, the courts of appellate jurisdiction have recognized that Martins, on the final judgment, it was a declarative judgment. Not a declarative judgment.
No important has been.
Unfortunately, we are out of time.
Shama, we still have some time, and I need to respond to some of the things they have said.
You have to do that in
at least 2 minutes.
No, 2 minutes is
But you
too
gave me
much.
more than 10 minutes.
It was his turn to speak. I equally rationed it. Actually, he had less
The
time to speak
issues that you raised at the Court of
in a
Appeal in Port
minute.
Harcourt confirmed via interlocutory applications, agreed. But that is not the final. Remember I said, while appealing the judgment of court, and if I seem to be acting in the stead prohibited by the court below, I hold no contempt of court. That is the law. I end there.
All right. Final statement in 30 seconds.
Yes, in my final statement, I will advise the Rivers State government to maintain status quo. The Rivers State government should recognize, they should maintain the status quo by recognizing Martins
That is not the status
and co.
That is not the
That is the status quo.
Jamala, thank you so much for coming.
But they need to do so.
We are out of time.
If they do so, they will lose the right of
Barrister Jamala, you are learned, correct? Act like one right now. Thank you so much for coming.
Thank you, Chairman. Thank you.
Thank you for coming.
Thank you for having me.
It's a pleasure having both of you.